The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today in the matter of three cases. The case of Heartland versus Monster et al. Is hereby submitted without oral argument. And our first oral argument today is Heartland Co-op versus Nationwide Agribusiness. Mr. Lorentzen, you may begin.
Good morning, Chief Justice, members of the court, counsel. In this case, the court is being asked to interpret the policy limits for earnings and extra expense coverage. That limit is $3 million for any one loss. The problem is that the policy does not define the term loss. The district court and the Court of Appeals both quoted Black's for its definition of loss in the insurance context, and this definition is actually helpful. It is the amount of financial detriment caused by an insured's property damage for which the insurer becomes liable. This invites the court to consider the policy's insuring clause, also referred to as the insuring agreement, as a way of understanding the meaning of the word loss. Here, the insuring clause is found at page 218 of the amended appendix in the lower left corner. It is the first paragraph that is quoted in the demonstrative exhibit that is going to be used by Nationwide today. It is the starting point of the analysis that was used by the district court in the dissent that was filed in the Court of Appeals opinion. Heartland believes this should also be the court's starting point. The insuring clause describes the particular type of loss that triggers Nationwide's liability. It ties that particular type of loss to interruption by damage to property, and I'm quoting, at a covered location as a result of a covered peril. It is the localized earnings lost and extra expense incurred from business interruption at a particular covered location which defines the loss that's insured. The $3 million limit should apply to each and every such loss Heartland suffers during the policy period. Nationwide agrees there is no aggregate limit, and the policy provides for none.
The loss covers, I think you said, the localized earnings.
Yes.
Is that right? So I'm looking at Appendix 218, the paragraph says, we cover your actual loss of net income, and your is defined there, I guess previously in the document, as the entity.
Correct.
So doesn't that indicate that we're looking at the net income of the entity and not your individualized internal accounting for each location as it contributes to profit and loss?
No, it does not limit it in that way, because the trigger for coverage is only the business interruption, which is the earnings and extra expense incurred at a particular location that's caused by direct physical loss to that location. That is what the
That language, the particular location language. What are you quoting?
argument. But the argument is based on the language of the policy, which says that we provide the coverages described below, which would be the earnings and extra expense coverage. During the restoration period, when your business, which would be the whole business, is necessarily wholly or impartially interrupted by direct physical loss or damage to property at a covered location. Now, the suggestion that you
Find covered location.
location is defined by the schedules that are attached. There are 86 individual covered locations, and so you would look at each one of those to determine if there was, first, physical loss at that location, second, if there was business interrupted at that particular location because of the physical loss, and then the question would arise is that what earnings, which would be
When you're looking at that schedule, what's the purpose of location 87?
for location 87 is to describe a variety of different kinds of limits that apply to different kinds of coverages. And location 87, which is not a particular location, but all of them, applies the limit for any one loss to all of the covered locations.
Or if it had said any covered location or per covered location or something like that, right?
Could have been clearer or not. I mean, Nationwide wrote the policy. The fact of the matter is that it says what it says. It could have been clearer if it said it was a per occurrence limit, as Nationwide argues. It could be clearer if it said there was an aggregate limit, as the Court of Appeals held, but it doesn't.
Reading of the location schedule, Appendix 230, number 87, all covered locations, means that each of the limits applies to each location for each loss.
I'm only interpreting it in the context of the earnings and extra expense limits. The other limits that are provided.
So there's 1, 2, 3, 4, 5 limits listed on Schedule 87. And your argument is, for some particular reason, the one about earnings applies to each location, but the rest of them apply to all of them in the aggregate?
The rest of them, I think you can say, apply to certain kinds of property, which is, and when I'm talking about physical property, the earnings and extra expense coverage is a financial loss, which is, like I said, specifically defined by the insuring clause of the earnings and extra expense coverage. And as a result, it's different than the other types of physical property that are provided for in limits. You have to interpret them separately. You don't interpret them the same because they're not the same kind of property.
One of the other coverages for location 87 is computers, $2 million. So if there was, say there was an electric something that caused computers to go out, say in location 2 and 3, Belle Plaine and Blairstown, 10 miles away, happens at the exact same time. Is that one loss, and is the $2 million apply to both of those, or does each location get $2 million worth of computers?
That $2 million could apply to any loss, to any computers, anywhere. And whether it's actually an aggregate loss or not is not an issue in this case, but it could be. Because it's a particular class of property that only is going to receive a maximum amount of benefits. And I think you could arguably say for the period of the policy. Not so, though, with earnings and extra expense coverage, because the earnings and extra expense coverage limit is for any one loss. That contemplates that there could be more than one loss during the policy period to more than one location, and the $3 million limit would apply separately to each one. Nationwide acknowledges that this would happen.
Any situation where there would be more than one location would be considered one loss for purposes of the business interruption? Or each location, because it's a separate location, has its own?
I think that the court should start with the premise that because of the way the insuring clause is written, each location needs to be considered separately to determine what physical loss at that location may have interrupted or resulted in the loss of actual net income, extra expense. Is it possible that two separate locations could combine and have the same business interruption effect. Hypothetically, I suppose it is, but it would be a fact issue. It would be something that could only be resolved at trial, certainly not simply by interpreting the policy, but it would be fact dependent.
I want to go back to this issue because I want to understand your argument kind of in the strongest way you're presenting it. And I really don't understand the distinction you're making between these 5 different limits on the schedule. I mean, the schedule sets forth the limits for a covered loss or risk for certain categories of risk. And I don't understand why this particular line relating to earnings somehow applies differently than all the other risks. I mean, as I read this, if your argument is correct, Nationwide bought $2 million worth of computer coverage at each location, which doesn't make any sense, right? Okay, then you're going to have to kind of re-explain it to me on why this one line gets applied to location by location, but the 4 other lines are just a limit for total loss, regardless of the number of locations.
Because the 4 other lines refer to coverage for certain kinds of physical property, which if you go back into the policy itself and the coverages that are provided, the limit that is described in the policy itself does not say for any one loss to those other 4 types of property. It does, however, say it with respect to earnings and extra expense coverage, and that makes earnings and extra expense coverage different, because what we're asking you to interpret is what losses for any one loss in earnings and extra expense, and not the coverage that's provided for physical property that may be located at more than one premises. There could be an indefinite number of earnings and extra expense losses that are suffered by Heartland during the policy period, and Nationwide would have to pay for each one. Nationwide agrees with this. Nationwide has agreed that if there was a loss at one location because of windstorm, a loss at another covered location because of fire, a loss at another location because of some other peril, let's say hail, there could be 3 separate earnings and extra expense limits of $3 million applied to each one. And there's no limit. And so any argument that would try to limit the number of $3 million coverages that are available would conflict with Nationwide's own acknowledgments and positions.
Point, the Court of Appeals focused a lot, I'm on Appendix 223, under the how much we pay, and it says we pay no more than the income coverage limit indicated on the schedule of coverages for any one loss. And the Court of Appeals really focused on that any one loss. What's your response to what they wrote on that point?
I would say any one loss has to be determined in the context of what was the business interruption caused by physical damage at a particular covered location. And that's Heartland's position on the matter. I think that what the Court of Appeals did was they avoided the occurrence issue because they didn't have a holding that was tied to an occurrence. But what the Court of Appeals did was they came up with a limit that aggregated all of the losses at all of the locations, but that's not what the policy says.
There was one derecho, and so with one derecho, there's one loss, no matter how many facilities it hits?
The court concluded that. I don't think the Court of Appeals did. I don't think the Court of Appeals tied their interpretation of the limit to a single occurrence or multiple occurrences. I think the Court of Appeals understood that the policy doesn't provide for that.
Would this apply in kind of a simple fact pattern of, let's assume you had a company with the same policy and they have two facilities, A and B, and there's a loss at A that causes destruction of it, but the production's easily transferred to facility B, and there's no loss of net income to the entity as a whole. How is that covered under the policy?
Addressed in the policy because the insured is supposed to take efforts to, excuse me, minimize the amount of lost net income. And so whether the insured in that case transferred it to another covered location or to a location that wasn't covered under the policy at all, in other words, rented another facility, that would be a way not to determine whether there was a loss at that location and what it was, but rather to minimize and reduce the amount that would be covered and paid under the policy. I see that my time is about up.
Look to the loss of the entity as a whole? I mean, under your reading of this policy, I don't know why the covered company couldn't say, well, I have 100% loss of income at facility A, and you look at each location separately, and even though I had no loss of net income at the entity level, it's still a covered loss to that particular location, right?
It is still a loss at that location, but if the loss is able, if those operations can be transferred somewhere else, replicated someplace else to reduce the net income that lost, that will reduce the amount of the payment that gets made. Thank you.
May it please the court. Mr. Lorentzen. This case is as simple as checking the right box. The schedule of coverages and the location schedule of Nationwide's policy unambiguously provide that the limit for Heartland's earning and extra expense loss is $3 million at all covered locations for damages caused by the derecho. If the parties had intended a different result, they could have checked the other box. This policy is a commercial output program policy. We call it COP for short, and it involves a couple of different parts that I think we'll get to today. There's a property coverage part, there's an income coverage part, and as I've mentioned earlier, there's a schedule of locations and then a schedule of coverages and a location schedule. All of those four parts fit together. And I would submit to you that you can get to the answer to this coverage question in 4 easy steps. The first step is actually an area where I agree with Mr. Lorentzen. We always begin with the insuring agreement. And the insuring agreement is the top item in my exhibit. I won't read it for you, but if you break it down into its individual parts, there's always 6 factors that are going to be required to trigger coverage for an earnings and extra expense loss. The loss has to occur during the period of restoration. That's a specifically defined term under the policy. The loss has to be to your business. That's also a specifically defined term. Your business has to be wholly or partially interrupted. That's the third factor. The fourth factor is that interruption must be by direct physical loss of or damage to property. The fifth factor is that damage has to occur at a covered location. And then I think the final factor, and perhaps the most important factor in this case, is that all of that damage has to be caused by a covered peril. So that leads us to the second step. If we move on in our income coverage part, we get to the how much you pay provision. And there's 2 paragraphs in that provision. The first paragraph informs us that the property coverage part and the income coverage part go together, and that the terms of the property coverage part may also apply to an income loss. The second paragraph, I think, leads us in our next direction. The first sentence is, we pay no more than the income coverage limit indicated in the schedule of coverages for any of one loss. And I think there's two important parts to that sentence. First of all is it directs us to our third step. If we want to know the limit, we need to go next to the schedule of coverages. And then the second part is that limit applies for any one loss. And so let me take this opportunity to explain to you what I think that term means. And that is this. Loss is defined in the insurance context as the financial detriment caused by an insured's property damage for which the insurer becomes liable. So how do we know how the insurer becomes liable? Well, we need to go back to the insuring agreement for the particular coverage at issue, and that's the insuring agreement in the income coverage part. So here, for any one loss means the happening of some occurrence or event that triggers all of the 6 factors in the insuring agreement in the income coverage part. And as I mentioned here, the key thing is here that covered peril is the derecho, and there's only one derecho.
Effect, loss, and occurrence. You could have substituted occurrence and it would mean the same thing here.
I think that they're intertwined. The occurrence would be the event or happening, the peril, if you will, that triggers the financial detriment being the loss.
Respond to Mr. Lorentzen's argument that when you get to the schedule, the income limit is different because the any one loss language is only in the income part of the coverage and it doesn't apply to the property pieces. I think that's what he's saying, that any one loss makes that part different in how you apply the limits.
The property insuring agreement, it's going to have that same covered peril requirement. And so I think that the effect is the same in that those limits apply on a per peril basis.
So do you agree that if there had been let's say we have 3 plants, and there's a derecho at plant A, and a flood at plant B, and a meteorite at plant C, that all at the same time, same day, that those 3 would be separately covered, but because there's one derecho that hit all of these facilities, that's why there's only the 3 million limit for all of them?
I agree, and the distinction, in case it's not apparent, is because your hypothetical involves 3 different perils. In our case, we only have 1. All right. So let me do this. Let's move on to the third step. That's our schedule of coverages.
You said that your 6 steps come from that first paragraph. And so interrupted by direct physical loss of or damage to property at a covered location. Oh, I'm sorry, as a result of a covered peril. So it's a covered peril that when there's one covered peril, then that's what makes this derecho be one loss. Okay.
Distinction, and I think that's the issue that I would take with Heartland's argument in this case and in the dissent's argument in the Court of Appeals. Now, I don't know if you'd like me to address the fact that the derecho is one peril. I want to mention it briefly, and I'm happy to get into any further detail. It's kind of the white elephant in the room here. The derecho is one loss. And Iowa applies the cause test to determine how many occurrences there are. If you apply the cause test to these particular facts, it can only lead to one result. And a picture's worth 1,000 words. We have all seen those Doppler radar images of the derecho going across the state. That's a single storm. Any layperson would call it that.
We call it the derecho. Even now, 5 years later, not the derechos.
We have a report from a meteorologist that says in the meteorological community, it's considered one storm. The VeriRisk PCS Catastrophic Loss Index indexes these storms across the United States. The derecho is on their list, and Nationwide's reinsurance program treated that as a single event as well. That's a very important point to note.
Come be the same if it was a tornado? Because as you know in Iowa, How do you know if it's the same tornado that hit one property as another, but a bunch of tornadoes go through town in one day? Would that be different?
I think those might be different facts, but let me explain it to you this way. There's no dispute that the derecho was a single event. If someone were to say that there was different tornadoes that occurred at different times, we'd have to look at the facts of that particular case. All right. So in our schedule of coverages, and this is back to our third step, this is at page 2 of the exhibit at the top. There's 2 options. There's a coverage option and a limit option, and it's a pick the option that you want. For the coverage option, the earnings and extra expense coverage was selected. And for the limit, the refer to the schedule of locations box was checked. So that leads us to our 4th step. But before I move on, the more important point is that the other box option was income coverage limit. The most we pay for any for loss at any one location is, and then you insert the blank. That's the box that could have been checked if Heartland desired per location limits for its.
You think so? And here we are today. Okay. Persuade me. I don't think it's obvious. Persuade me. Why is that? Why does it say that? And here I am thinking that the insurance policy needs to say more, because we all know insurance policies are incredibly wordy. But of all the words you have in the policy, how is that Captain Obvious?
Let me explain it with a couple of rules of interpretation. One is it's not ambiguous because the parties disagree. And it is also not ambiguous because it could have been worded more clearly. And I would cite to you the Just Be Farmers case for that rule of interpretation. The third rule of interpretation that is more directly on point to what your question is that we attempt to interpret policy language such that we don't.
Tell me how can that be interpreted to not be ambiguous?
If that box meant something different than a per location limit, then there would be no reason to have this other checkbox and refer us to the.
It says refer to scheduled locations, plural. That kind of sounds like, you know what, the list, and that list has like 1 through 83 or 4, whatever it was. So when you compare it to the second checkbox, that's what tells me I think it's ambiguous.
Well, let's look at what the location schedule says, and it's location 87 for all locations. So
what you're saying is, if they wanted to do a per location way, you check the upper box, and checking the lower box said, all right, you go to the schedule, and there's some limits for individual locations, and then there's a limit for all covered locations, which has to be an overall limit, because otherwise the other box would have been checked. Okay.
Read those 2 provisions together.
He helped you out there, didn't he?
But let me ask you this. I mean, the dissent says you can't look at the language that isn't checked. I'm not sure that's correct, but they make that point. Judge Langholz says you can't like look, you know, that's not actually part of the text of the policy because it isn't checked. How do you answer that?
Well, I think that there are some case law here, and I think it's the Just case that involves a checking of a box, and there was some options in the policy, and the inference was by checking one to the exclusion of others, that is evidence of our intent. Going back to the schedule where it says all locations, the only way that that gets interpreted in favor of Heartland is if you change the word all to the word each, and that's not what the policy says. All right. So let's talk about some of the rules of interpretation that can be applied in each of these 4 steps.
Was that step 4? Step 4 was look at the schedule and the word all means all. Is that? Okay. I just wanted to make sure.
If you go through and check out the individual locations, the 86 others, you won't see a income and extra expense limit individually stated at any location. All right, so let's talk about some of the other rules of interpretation. Let me start with step 2, because I think we've covered some of these already. An insurance policy should be read in light of all of the declarations, riders, and endorsements that are attached. And if you look at the how much we pay provisions in the property coverage part, you'll see that the deductible provision refers to the deductible being applied in any one loss, or I'm sorry, in any one occurrence. And there's also a windstorm and hail deductible that has similar verbiage. And I would submit to you
About the cost of this additional income protection. What was the premium paid for it?
let me go to my notes on that. The premium for the earnings and extra expense was $2,760, and that was based upon the $3 million coverage limit.
Reflect at all what the current market price is per million for this kind of coverage?
It doesn't have current pricing, but there's an affidavit from Jason Berkland, who's the Associate Vice President of Underwriting at Nationwide. It's at appendix page 802. And he explains how that premium was calculated. And basically, there's a rate that is provided. And then that rate is applied to the limit, and then you divide the limit, that number by 100, because the rate applies per $100 of coverage. So here, if you wanted to do the math, the 3 million times the rate, which was 0.092, divided by 100 gets you to $2,760. If you were to run the numbers on how much the rate, how much the premium would have been for a $3 million limit at 86 locations, that number would have been $2,370,000, a significant different price difference. And we've cited authority in our briefs that the Iowa courts consider premiums when interpreting the policy language. I see my time is up, so thank you for the opportunity to present argument.
What is your response to that last mathematical calculation regarding the price would have been about $2 million more to cover all the properties?
I think that's irrelevant. The reason why is because Nationwide has agreed that the way they wrote the policy, there are an unlimited number of losses that could be covered with a $3 million limit during the policy period.
One, why is it irrelevant? Because we have cases that say it is relevant. But two, we have two sophisticated commercial entities who negotiate a very complex insurance agreement. They both understand how the pricing works. And I guess I find it incredible to believe as a reasonable commercial agreement between these entities that they mispriced the coverage for this policy by a factor of 100. And that's what you're asking us to say, is they bought $250 million for insurance coverage for $2,700. And that is implausible to me. So I guess I'd like you to respond to it to the extent it is relevant.
Plausible, but the thing is that that's not what was purchased. They did not purchase $258 million worth of coverage. They purchased $3 million worth of coverage for any one loss. And what was sold is there is no aggregate limit. There is no catastrophic limit. Nationwide sold a policy for which there was an indefinite number of 3 million limits. It's not that they sold a policy for 258 million.
Carrier's perspective in terms of insuring against the risk, or if you had to reinsure it, that's a $258 million risk, right? It's $3 million of risk per location.
There is no location limit. The box was not checked. There is a per loss limit. And Nationwide agreed that per loss, there could be an indefinite number. It's not that Nationwide is saying, okay, if Heartland is right, now we have $258 million worth of coverage for 2,700 and some odd dollars. That's not what they sold. What they sold was $3 million per loss, and they agreed that there would not be any aggregate limit, and that the number of losses that could occur during the policy period is indefinite. And they could charge whatever premium they want for that. And there is absolutely no evidence in the record that the premium they charged is either unreasonable for that kind of coverage, or that it, more importantly, that it was ever discussed between the parties. I mean, Nationwide simply said, we're going to sell you this coverage, which is provided for in the policy, and they did say, okay, here's the premium we're charging you for the income coverage part, but there was never any discussion about how that calculation was made. The evidence that was offered by the underwriter, for example, that was never, none of that was communicated to Heartland. Heartland had absolutely no idea how or why Nationwide was charging that premium.
Well, is this derecho more than one peril?
So, weather events, it all depends on at what level you're looking at them. So you could look at the entire weather system for the world, and in which case every weather event is caused by the same peril. You could focus more on macro events, which would be like the derecho, okay? Or what our expert, Mr. McClellan, reported in his discussion, he said that, that there were multiple storm cells, multiple microbursts, each of which had their own destruction path, intensity, like multiple tornadoes. And those are fact issues for trial about whether they might be different events. But it's all a question of from what perspective are you looking at weather in the world?
Terry, to your argument, is it that there be just multiple perils? It could just be one peril, right? Your view is it's still $3 million for each location is still a separate loss. Is that your view?
And that is what the insuring clause provides, because the last two words of the insuring clause are that the damage has to be caused by a peril. It doesn't restrict it to the single peril. It says a peril. A means any. It could be caused by the same peril in two different locations. It could be caused by different perils in two different locations. The insuring clause doesn't distinguish that in determining what loss is covered. Neither does the limit language. I see my time is up.
Versus Nationwide Agribusiness is hereby submitted. We'll have a brief pause while the next attorneys get ready for State versus Cole.